Your Honor, in relation to the supplementary application or affidavit that was submitted, I have it in hand. This is my reply, but unfortunately it's not commissioned, number one, and I have annexures that are to it that needs to be copied, and I need to have a copy. This is my original. So there's no way I was taken while I was writing, and I was not done.
I understand that, Mr. Bester, but if you recall, before we adjourned, I gave you 4 or 5 opportunities to stand this matter down, and you chose to be here at 2 o'clock. And that is, unfortunately, that's where you now sit.
That's fine, Your Honor, but at the end of the day, I can't submit an affidavit that's not commissioned. It's also not commissioned.
And that is why you were given 4 or 5 opportunities, Mr. Bester. So we are here because you insisted we are here, and you received. And if you recall, I explained to you several times that if you don't find them, you are bound to your founding and replying. And you insisted, despite me asking you several times if you want to stand down on Thursday, you insisted 2 o'clock, and it is now past 2.
Your Honor,
Please continue. There is no further effort.
Can I-
That was your choice.
can I finish? So I'm saying, can I finish what I'm stating? Please. The process of commissioning this, it's not up to me, Your Honor. I'm in a cell, and I have to get authorities to commission it. I have to get authorities to approve a complainant request to go and make copies somewhere else. It's not up to me to make those copies in my own cell. That is why we are here, Your Honor. I do not have access to those things. So I was not able to get these things commissioned. I was taken immediately to come here. I explained that I am not done in the sense of making copies. I was then informed I should request the court for a postponement, which is not in my doing. This copies, I have all my documents here. If the court wants to make copies for me, I have no problem. Do you understand? But at the end of the day, it's the process within prison that blocks me from making the commissioning officer is a member of correctional services. I have informed the head of prison. He did ask me to request for a postponement to get this affidavit commissioned. There's absolutely nothing I can do about that, Your Honor. And second, my annexures, which are pertaining to most of the allegations brought by the respondents, I cannot put them because they are my original copies. So if I submit them, I do not have any documentations with me. And that's basically what I need the court to understand. And then moving on from there, Your Honor, I will address the court as the court wishes, but I do want to highlight that I feel that the court is being prejudiced towards me. Your Honor, dealing with the responding, a supplementary affidavit that's submitted by the respondents, Your Honor. As mentioned in my replying papers, that the facts of the alleged or allegations put that have not been tested by any court of alleged escape or alleged fraud cannot be entertained by this court because evidence has not been tested. It's allegations. And at this current stage, I am one of the inmates that are most in public have numerous allegations. None of those allegations, the respondents mention a case of fraud. I have never been charged for that case that the court has accepted affidavit today. Second, I do not have number of the supplementary affidavit that has been added. I do not have the annexures that are mentioned in the document. I do not have the so-called complainant's affidavit as mentioned. I do not have DCS 1, DCSA 4 and 3 and 5. I only have 2. And meaning that I do not even have proper papers to be able to respond to it thoroughly. And under the uniform rule of the court, under Rule 6(5)(e), is that there are 3 sets of affidavit the court has to accept, which is the filing affidavit, responding affidavit, and answering affidavit. And right now they are adding more affidavits, and the court accepts it. And I feel that that's prejudice to me automatically, because they should file a motion and add that information that they are placing before this court. I do not have access to test the evidence they are putting in the supplementary affidavit. Second thing, Your Honor, is that under Section 35, I have the presumption of innocence until proven guilty. So these allegations that they are putting before this court, which is escape, has not been proven, has not been tested. The allegations of fraudulent charges against me or Mrs. Makutumana has not been tested. So we are basically speaking on hearsay evidence, and that cannot be tested by this motion court because there are criminal matters and other matters that are before another court. And under my constitutional right, I have the right to remain silent. And that is a matter of fact that I cannot come and address that fine supplementary affidavit in this court, because those are criminal charges that are before another court. And the court accepting that is prejudice to me, because if the court has to look at the actual application, which is access to legal resource, and it is written in a filing affidavit as access to legal resource, and I refer to access to a laptop and internet. But I am not saying the respondents cannot limit, supervise, monitor these devices. In actual fact, I have highlighted today to the court that access to digital content it's not a new thing. It is something that is already managed by the respondents, and there is no security bridges in that sense. The respondent create their own security bridge because they are alleging that I have escaped. They say I have committed a crime, but they have not proven that crime, Your Honor. And I am now prejudiciously forced to comment on a case that is before another court. And I find it truly unfair for me to be before this court, have to answer for a matter that has not been tested. The affidavits added in the supplementary of the investigating officer and etc. I do not have them. The so-called statements from the complainant, I don't have it. And we cannot bring them to the box and actually get them to testify and see if this is relevant or not. There are numerous allegations, Your Honor, and I feel that, honestly speaking, with all respect, it would be unfair for this court to expect me to even touch on any of these allegations because they are a matter before another court. As the advocate has mentioned, there is a case in Bloemfontein of escape, and that should follow its process. The respondents only based on legal resource is the basis that I am now before the court. But the court itself has in black and white that the matter was supposed to sit down on the 16th. It couldn't sit down on the 16th because of lack of resource. The respondents goes further to say that I have numerous counsels visiting me on legal basis. Your Honor, these counsels, as any person would understand, any counsel has a specialty, and I cannot take a counsel that says to me that they cannot take the legal obligation of representing an application that is not within their scope, where they will lack legal understanding. It is then within my own that if I can't defend myself, no one is going to defend me. I am the monster here. And if I'm not given an opportunity because somebody believes that my resources are enough, the court has full evidence. I have stated in the replying affidavit that I tried prior to drafting the application. I took about 14 months to draft the application that is before the court as the main application. And I've put it here. I've also added 5 different copies of different versions that I've handwritten myself of the same application. I have taken information from the first application, which was done by Mrs. Makutumana. And in that, I have tried to build my own defense. And I have done the best with the resources I have limited. And I have stated that from November the 6th, 2023, Correctional Services was the first time they allowed me to have books and access to information. This information is so-called limited. I cannot get the press, which I have highlighted in my affidavit. I cannot get the press briefing on the 8th of April, which was done by government, stating the reasons of deportation, which are fundamental in the main application. Your Honor, this application is not an application self-created. There are numerous attempts that is before the respondents where they have a complainant request book. If Your Honor could request the complainant request book, they have strategically not added the copy because it states how many times I have been denied access to books and access to legal information. At this point, if I had to write an application to request any documentation of legal reasons, I have to state the reason of my application. I have to state why and how long. And I feel that, Your Honor, in that current position, it is prejudice to me. Second thing, Your Honor, the respondent alleges that the application does not meet urgency. Urgency in the application could have never been self-created, Your Honor. The application has been brought by a person who does not have representation. Once counsel dismissed the brief, I cannot come here and disclose briefs that have not been accepted of counsel. That would be me being prejudiced to those counsel. I have to respect their decision. Any person has a right to take whatever brief they choose. And in that, Your Honor, I filed my own application. And in filing my application, I wrote a request, which I have here, which is in the reference book of Complainant Request 144, 2024, and 2023, requesting the respondents, may I please have you type my documents. At that time, I had no intentions of a laptop or anything. I just asked for access of typing. And in that, it was rejected. So, Your Honor, if the respondents say that this is self-created, I have requested to have access to this media briefs. They still rejected it. So I am not here asking that I am given a luxury of a laptop or anything else. In all events, if Your Honor, if you follow the process that I have followed all the internal issues, and I have then taken the matter to a point where I am now have to put an urgent application. And in the urgent application, the respondents did not have the application as they allege on the 23rd. They had the application on the 13th, when it was commissioned. The commissioning of oath has a stamp of the head of prison. He had it immediately. And they fully understood what my challenges were. From that point until now that we come before the court, I have been having back and forth. Your Honor, the register of this court will explain. Yesterday in the afternoon, I had to get an assistant of a third person to call the court to ask for a requisition. If I had not done that, I would not be before this court. And this court is digital. It is not my choice that the court goes digital. And it is absolutely would be unfair of me to expect a third party to do as I wish, when I wish, as in accessing my applications on my times. And I feel that the respondents have not proven at any point that I do not have, I have numerous access to legal resource. They are saying that I'm self-created. They are saying that I have access to legal visit. But Your Honor, a criminal attorney is a criminal attorney. We're talking about a civil matter. This is a civil matter before a civil process. And I cannot take somebody who's before a criminal matter who insists that they cannot represent me on a international civil matter to come and do that. Because they are bound by practice of the attorney rules. I cannot do that. And in that, Your Honor, it is this application makes thorough sense that the respondents does not even touch on the fact that they can monitor access to a laptop. They can monitor access to internet. That the allegations that have been put before the court, I clearly stated to the respondent in my reply that I was released from prison. Facts further on that will be highlighted in a criminal matter. I cannot disclose any issue revolving the criminal issue. And I feel that, Your Honor, it is biased of the respondents to take the fact that I'm not able to commission this and say that I have not submitted. I cannot write 10 copies of this in handwriting. It's 11 pages. And I have numerous copies that I have to do. So I feel that the court can make the decision as I feel that it is already clear to me that I am not understood. Any person in this country, including inmates, are human beings that have the right to fight for their constitutional right. It's a fundamental in the Bill of Rights. Section 38 states that if any infringement of the Bill of Rights is enforced, you have the right to take legal action. I have taken that step, and I believe that I do not have access to legal resources that allows me to freely access this court meaningfully. I do not have meaningful access. There's a difference, Your Honor, between access that's limited, that deprives you of filing and taking litigation issues on time, and access that is freely within monitoring what the respondents can truly manage. This is, I believe, not in the best interest of anyone. And in that, Your Honor, the Bill of Rights clearly states that we all have a right to fair, equality, justice, and law that is protective. I am supposed to benefit as freely as the respondents in the main application. Am I going to be able to benefit as they benefit from law and access the law? I am not. Your Honor, even the main application, which I've added here, is that they have taken 28 days to 32 days to file a notice of intentions to oppose. They've taken 30 days to oppose to the responding papers. I was not able to file an application to this court to notify the court that the respondents are delaying the process. I cannot do anything in the current circumstances that I'm in. And secondly, Your Honor, I have highlighted in this affidavit that, and in my founding affidavit and my responding affidavit, that I am not under normal circumstances incarcerated. I am under circumstances that are inhumane. I live in a cage, I exercise in a cage, I am by myself. I don't even have time. So does that mean that because I am Thabo Bester, I have no right to access to my constitutional right? Because if I listen to the respondents and I listen to the court's submission and understanding, I feel that it's already giving me the impression that I am prejudged on the fact that I am Thabo Bester. The facts before the court speaks for itself. I am not asking the court for anything. I have stated that in numerous countries there was libraries that were law libraries that had access to printing these documents and typing these documents. But CMAX does not have that resource. It does not have that assistant. It cannot even assist me with typing a document. As you can see, my responding affidavit is in handwriting copies and commissioned and sent to the court because I cannot get anyone to type it. And all I am asking the court is to consider these facts. And also, Your Honor, taking into consideration that the respondents argue that my application has no basis on the basis that I have numerous access to court. Your Honor, I am before this court, but as I've explained, and as the register and numerous correspondence that are to this application proves that it was a struggle to get before this court. Now, I am fighting for my life where I am going against 7 departments of government. Now, regardless if I am not Thabo Bester or Thabo Bester, but the law says that we are all equal. Now, I deserve same access. I deserve the same amount of protection from the law. And right now, I do not feel that even accepting this supplementary affidavit, that the court accepted without even asking, without hearing my response or hearing my opposing facts. And that confirms to me that I am not going to get a fair treatment. And I understand that it is what it is. But at the end of the day, it is my life that I am fighting for. All these allegations that the respondents has put before the court and the finding the supporting affidavit, nothing has been proven. And if I had to entertain them to any level, I could shoot so many holes in that application. But because by law I am bound to take the matter before another court, the fraud allegations, I'm not charged. It is as good as any allegation put out by the media. How am I supposed to bring this and take these issues and address them to the court and test the evidence of it? I don't even have the proper annexures of the supplementary affidavit, Your Honor. And I request the court to understand that as a layman, there are mistakes I would make in this process. But it is the court's responsibility also to assist and guide me in certain factors. I have explained why this is not commissioned. I have explained my position why I have not been able to submit. But the court already, speaking to the counsel, already stated that the court does not care. And the court is not going to be entertaining whatever reason I have. And that is prejudice, and it's unfair.
Mr. Bester, I didn't say that.
Your Honor, you said that.
No, I did not say that. So let's move on from that. You chose to be heard at 2. You were given a full opportunity to file a response by Thursday. You chose to be heard at 2. You are sitting in the position you're sitting in because of your choice. And despite that, Mr. Bester, everything that I'm hearing not on the papers before. I am listening to you despite that. So please move on.
Your Honor,
Let's finalize this. You've made your submissions. Is there anything further? You are welcome to make further submissions, Mr. President.
Yeah, Your Honor, I just want to know how would I be able, because I have added this in my everything that I've stated now in my affidavit.
You have told me that what you're telling me now is in your affidavit.
Yes. So I just want to know how would I get it to you, so since it's not before you.
You've made your submissions, Mr. President. Is there anything else you'd like to submit? Welcome.
Just on the closing point of my submissions, Your Honor, I want to state that under the current circumstances of the respondents depriving me of access to justice, Your Honor, I feel that it is unconstitutional and it is in the best interest of myself to be able to bring this application before the court and request the court to take in consideration the reliefs that I seek, and if any alternative reliefs can be provided or directive by the court in being able to provide me with any access that is meaningful to the current circumstances is all I seek. I pray to this court to take consideration that within the current circumstances, I have clearly stated what my position is, that I have given evidence beyond reasonable doubt that I am under circumstances where I cannot access even a diary. And because of those small factors, they make a huge difference. If you cannot take a diary of notes to a point where the court says I can access books, accessing hard copy material is as hard as accessing a diary. And in this current circumstances, the court, regardless of how the request or reliefs are appointed, all I am requesting is assistance to be able to file my main application. I am not requesting for a specific, as long as I have access. The respondents can provide any means or any way that they are able to provide me with meaningful access, that I'm able to access the evidence that I've stated, and that I'm able to file my application and be able to represent myself as best as I can, which is what I am constitutionally given. And I request the court to take that into consideration in this whole process.
Declaring the conduct of the respondents in refusing the applicant's request to use a laptop or tablet or form of devices in the preparation of his application and have access to court online to be unconstitutional and invalid in terms of sections 9, 32, 33 and or 38 of the Constitution. 4. Declaring the conduct of the respondents in refusing the applicant's request to information by documents or interest in preparation of the application and further legal matters and research to be unconstitutional and invalid in terms of sections 9, 32, 33 and 38 of the Constitution. 5. Declaring the conduct of the respondents in refusing the applicant's request to use a modem and printer in preparation of this application and deportation application and access to court to be unconstitutional. 6, declaring the conduct in refusing the applicant's request to communicate or visit by expert and witnesses for the preparation of the application and legal matters, or taking legal action to be unconstitutional and invalid in terms of sections 9(1) and or 33, 34, 35, and 38 of the Constitution. 7, declaring the conduct of the respondent in refusing the applicant's request to use a diary in preparation of this application and deportation application, and planning for legal and anything pertaining to my life to be unconstitutional and invalid in terms of section 9, 33, 34, 35, and 38 of the Constitution. Close quote. That application never realized on Friday, the 16th of August 2024. The applicant explains, and I will deal with how the matter came to serve before me in the present founding affidavit, that he had trouble accessing the court online profile and he had trouble finding his papers. What is clear is that that application, the notice of motion for the set down on the 16th of August 2024, was actually served on the respondents after that particular date of hearing. Thus, the application was never heard on the 16th of August 2024. Suddenly, on the 10th of September 2024, the applicant set down the self-same application for hearing on the urgent roll of the 17th of September 2024. Between the initial application or deposing to the initial application on the 13th of August 2024 and the notice of set down, the applicant has abjectly failed not only to explain the more than 1 month delay, failed to explain why he cannot obtain relief in due course. The state vehemently opposes this application and has explained to this court in its main answering affidavit that this is not the first time the applicant has sought this relief. In an application launched in the Free State High Court on 24 July 2024, the applicant similarly seeks the use of a personal laptop for purposes of preparation for his criminal trial, and thus it appears what the applicant seeks to do is forum shop in the event that a court will eventually hear his matter on an urgent basis. I pause to mention that I am informed that the applicant is, for purposes of his criminal trial and deportation application, represented. Insofar as his application for deportation is concerned, there is no urgency at all, as the papers in that application are not yet finalized, no heads of argument have been filed, and no court date has been provided as yet until that application is in full before court. Thus, on all views,